Arrumar o campo,
dá para fazer sem
eu preparei uma pergunta em inglês, acho que eu vou falar para ele, acho que me faço entender em inglês, e depois eu falo em português. This is a question for Professor Michelman. My name is Marcos Manisca. I teach constitutional law at Brazil. And I would like to ask you in the context of his concept of popular constitutionalism. In your definition, popular constitutionalism is not a word void of constitutional right. There is no lack of commitment to a constitutional law that imposes limits and requirements on political actors, some of them correlating with rights held by individual and groups. This is the definition that is stated in your article. I have researched on the role of the Constitution in pluralistic society. Therefore, I am interested in knowing what role the state should have in view of various associations that do not share the same values, lifestyles and worldviews. I would like to know your opinion about an event that occurred in Brazil that we can bring here to discuss the role that the state should have in view of difference that characterize a pluralistic society. It was the realization of a gay wedding inside the Center of the Tradition of Gauchos. Centro de Tradições Gaúchas. The Centers of Tradition of Gauchos, CTG, you know, are private associations that preserve the traditions of Rio Grande do Sul, that is the state of Brazil. President of this CTG, this center, authorized the holding of gay marriage inside the center. However, members of this CTG did not accept that a gay wedding could have held inside the CTG, especially in September, when Gauchos celebrated Farroupilha Week. This is in honor of Farrapos War. The judge decided, in this case, decided that the tradition is not an argument for not performing the marriage. Tradition is not an argument for not performing the marriage. CTG members opposed this decision, set fire to the place of the CTG and prevent, in fact, the holding of marriage. Yes, the members set fire in the place and prevent the marriage. The wedding took place in the courthouse. The question, I have three questions. The first, what role should the state have in this situation? On behalf of the horizontal effect of fundamental rights, this German Dritte Wirkung der Grundrechte, should the state compel the association to perform the wedding? The state can obligate the association to have this celebrate inside the center, this association. This is the first question. The second question, the state should promote debate within the association that the association itself decide on matters on this nature. Yes, and the association itself decide on this question, or if the association in a free and open vote of its members decides that the association will not accept holding of gay marriage inside of the center, is it being prejudicial? This is the question. I don't know if you understand my question.
Well, let's see.
Eu não sei se vocês entenderam o que eu perguntei, na verdade, sim, ficou claro? Deixa eu contexto.
I'm going to try to, because the question is built around a set of facts in Brazil that I can generally get, but don't feel I have a command of. I'm going to try to respond by offering an American context, and then we'll see whether I've got the question correctly. There's, of course, in the United States, a huge debate about whether the United States Constitution or the Constitution of one or another of the 50 states confers a right of gay marriage in the sense that if two men or two women apply for a marriage license, even in a jurisdiction where the laws as they presently stand define a lawful marriage as a marriage between a man and a woman, would be entitled, nevertheless, because of the requirement of the Constitution. The relevant state or city official will be required to issue the marriage license, and the state will be required to recognize the marriage as a fully lawful marriage bearing all the consequences of a marriage in terms of parental responsibility, in terms of tax liability, in terms of succession to property in case one of them dies, and so forth. As you probably know, public opinion in the United States is divided about which should prevail. The freedom, the liberty, and freedom of association and claim to equality of dignity and respect of the couple applying for the marriage license, or tradition. The tradition, the Judeo-Christian tradition, it will often be described as, that restricts a marriage to a man and a woman. So, how? Is it only tradition that stands on the other side? In these disputes, we are told passionately by those who oppose the idea of a state or federal constitutional right to gay marriage that it's not just tradition opposed to liberty, that it's liberty opposed to liberty. Sometimes the opposing liberty, and now I think we're coming maybe somewhere in the neighborhood of your situation, sometimes the opposing liberty is described as a liberty, a right to live in a cultural environment, in a social setting that is not alien and antithetical to our deepest beliefs and commitments. There are some questions, the opposition will say, on which minorities, cultural minorities, sexual minorities, sexual orientation minorities, must be willing to bear burdens and make sacrifices so that the majority may maintain a form of life with which it can be comfortable. That's one way in which the opposition says there are constitutional level claims, constitutionally significant claims on both sides of this. There's a liberty of culture, if you like, as well as a liberty of marital association. Another way it comes up is when you have small business people, photographers, bakers of wedding pastries, who say, if there's a right of gay marriage, then you're going to enforce your state anti-discrimination law, your state law that prohibits discrimination on prohibited grounds in commercial transactions. You're going to tell me that I have to accept a contract to be the official photographer at what I regard as a sinful wedding ceremony. Or I'm going to have to accept a contract to provide the food and drink at an affair which I regard as against conscience. I think that latter claim is basically false and fraudulent because it would be possible for any state to draft its law in such a way as to avoid that kind of consequence, or for a court to construe most state or local civil rights laws in a way that would avoid that consequence. There would then be protests from the other side, from the gay marriage side, that they were being subject to a kind of unequal subordination of dignity by allowing this form of discrimination in the market. But that, I think, that question is manageable within the culture wars of the United States. That particular aspect of it is manageable. It's the larger question, which I think is the one that you meant in a way to put. The majority community's demand for some level of respect for its deeply entrenched values, even if it means the kind of sacrifice that a prohibition in a public or a private setting. I wasn't clear from your question whether the location in question was owned by the association or was it owned by the association. If it's owned by the association, the answer in the United States, as the constitutional laws of the federal and states now stand, would be what goes on in your private space is up to you. I don't think that any state in the United States at the present time would require the private owners of a space to celebrate gay marriage in that space. The question, though, remains difficult because even in the public cultural space, there's this claim that sometimes majorities rule, and they rule on the basis of tradition. You want to know my opinion? If I'm a judge of a state Supreme Court, I am going to rule in favor of a right of gay marriage. I'm from Massachusetts. Did I get the question well enough?
Que foi o primeiro estado dos Estados Unidos a aceitar.
I'd like to add just one point about the notion of popular constitutionalism. Because it could take one of at least two different forms. The form I'm most interested in and have written about and really have advocated for is an argument against a judicial monopoly of how to interpret the Constitution. So it's an attack on judicial supremacy. When the Supreme Court says, as it has frequently over the last now 50 years, we are the ultimate interpreters of the Constitution, I'm inclined to disagree. a written constitution, for better and maybe for worse, can be read by anybody. And here I also draw on historical differences between Catholicism and Protestantism in particular. And I think it's significant that the United States is largely, at least historically, a Protestant country. And what Protestantism stands for is the rejection of institutional priestly elites in favor, ultimately, of the ability of any member of the faith community to read the text and to interpret it. So this form of popular constitutionalism is entirely within the Constitution, in specific sense that somebody making a claim that I'm authorized to interpret the Constitution just as much as a Supreme Court justice would do, is saying this is the nature of the American constitutional order, which does not specify a basically papal role for the Supreme Court. There's another notion of popular constitutionalism, though, which is much more ambiguous because it might suggest an ability by we the people simply to reject the Constitution when we don't like it. So you can look, one reading of the American Revolution is that the British Constitution, British constitutional system was no longer acceptable because it didn't allow the self-determination governed by consent of the governed. So we overthrew it. And so I say this type of popular constitutionalism has a more ultimately radical or revolutionary edge. But the first kind, it may be radical politically in that I dare say most Americans do view the Supreme Court as having the last word. And so they might be troubled by somebody who said, no, the Supreme Court is entitled to its own opinions, certainly, and practically speaking, you ought to pay more attention to the opinions of the Supreme Court than to anybody else. There's no doubt about that. But if we're talking really at a combination of an abstract level, but also a direct political level, you could say, well, even if the Supreme Court has spoken, we are free to disagree and to organize a social movement around a different vision of the Constitution that nonetheless we believe is within the Constitution, correctly interpreted. But I do think the notion of popular constitutionalism is extremely fascinating and to many people extremely troublesome.
Bom, não sei, professor Stefani, eu acho que... Miguel.
So, Professor Levinson, I would like to hear you about what you understand as dialogues and how it would work in a judicial system, as the American judicial system, that gives the last word about the Constitution to the Supreme Court. I mean, what's dialogues and how it works in a judicial system where prevails the judicial supremacy. Okay? And Professor Michelman, I would like to hear you about what you understand as a weak form judicial review and how it would be possible in a judicial system as the American judicial system, where you might have a strong form of judicial review. And on the second last question to Professor Michelman, when you defend the existence of social rights but denies the possibility of the enforcement of these social rights by the judiciary, don't you think that you assume an artificial difference between liberties and social rights based in the cost of rights? I mean, if you accept that liberties can be demanded on courts, why couldn't you also demand social rights? Is this because just they depend on taxes or political choice? And then I would say that also liberties depends on taxes and political choices.
The question about dialogue is obviously extremely important and also extremely slippery. That is really to get one's hands on. A model of dialogue, in fact, Professor Michelman wrote about this as well a number of years ago, is a certain, I think, idealized, and I think today he would say that it's an idealized model of the Supreme Court itself, where a judge will prepare an opinion, will circulate it among his or her colleagues, will read dissents, will sometimes not only change aspects of the original opinion, but even change the vote. So you sometimes hear the expression, the opinion just wouldn't write. And there are some well-known instances, not dozens of instances to be sure, but well-known instances where a judge, after initially voting X, ends up voting Y because, and this is really idealized, but it's a version of, you know, the definition offered by Jürgen Habermas of dialogue is that you're persuaded by the force of the better argument, not by politics, where I threaten you with that you'll lose the next election. That's not the force of the better argument, at least as Habermas means it, though being told that you lose the next election is a very powerful argument indeed. So if you want to go beyond the judiciary, I suppose a model of dialogue is that the court issues its opinion or opinions, that a legislature has a mechanism. It's unrealistic to imagine that every member of the legislature will read the opinions and think deeply about them, but that they might have a committee composed of well-trained lawyers who really do read these opinions very carefully, try to summarize them. They can skip all of the jurisdictional parts and get straight to the merits. And then the more serious members of the legislature will say, these are good arguments, but we think these are better arguments. And in fact, we're going to pass legislation that brings into question the decision you made. But we're going to explain why we're not really accepting one version of your opinion as the last word because we think you've missed an important point. One can imagine, and here's where I might start sounding just too idealistic, because one can imagine a member of the court saying, you know, that really is a very good point, and it had not been raised adequately before, or circumstances have changed, and we're going to modify. We will distinguish the earlier case. To overrule an earlier case in a precedent-based system is a big deal. To distinguish an earlier case is just what lawyers learn to do in a common law system. Now, Judges are human, legislators are human. Few people like to admit in public that perhaps they made a mistake or they weren't aware of an argument. But at least one can imagine and even see occasional examples where there really is respectful exchange and realization. I mean, take the American system. The Supreme Court will hear argument, let us say, in February. The argument is highly adversarial, which means almost by definition that neither side wishes to be fully nuanced. It will issue an opinion in June. And if it's a controversial case, it may very well be the case that the opinions will be written in certain conditions of haste. There will be things in the opinion that are problematic, that if they had another 2 or 3 months to exchange memoranda, it would be better. It's a little bit like the case Mr. Michelman mentioned, where there's one provision in a 2,000-page Obamacare legislation that is troublesome if you're a certain kind of lawyer who wants to kill the Medical Care Act. There's no doubt that if this had been brought to Congress's attention, and if Congress were capable of functioning, which it isn't, then they would have corrected this. But instead you have this mistake. So the Supreme Court opinions, even if they're dialogical in some ways, they exchange memos, it still isn't what academics do, where we will write an article, we will send it to friends, we will workshop it within the United States, perhaps outside the United States. I've given another paper, not the one I talked about today, recently in Canada, Italy, and Great Britain, and gotten very, very interesting responses there. And then, a year or so later, but it will be 2 or 3 years later, perhaps, after the initial draft, we'll publish it. That's not the way judges can operate. Because, and I don't mean to be disrespectful, they're hired to make decisions in real time. A judge who says, this is really difficult, I want another year, is not behaving the way we expect judges to behave. They do the best they can within 3 months. But it would seem to me that they ought to have the humility to recognize that the best they can is not going to be perfect. And perhaps they should pay attention to what other bodies say. So that's the very idealized notion of dialogue. And when Professor Michelman turns to weak-form judicial review, that, in a certain sense, addresses or how to make concrete these very abstract sorts of concerns.